And we're rolling. Good morning, good afternoon, and good evening. This is Richard Elsager here on the Car Brief web channel. This is a channel devoted to everything automotive related in a legal setting. I'm a lawyer that practices in Chicagoland. I handle a variety of cases with a focus or concentration in the area of automotive accidents, personal injury, and traffic related offenses. Bulk of my practice is automotive related or car accidents, if you will, personal injury, and also, as I mentioned, traffic tickets, license revocations, license suspensions, all kinds of traffic related offenses. So tonight, as you can see, I've got the Sunoco theme going. That was a very popular gas station in the 60s. It's popular yet again in NASCAR, I noticed. They used to offer top grade fuels for muscle cars back in the 60s. You could get really high octane out of the Sunoco stations. I remember growing up in Toronto, and Sunoco was all the rage for gearheads, and we enjoyed getting that gas. Although I'm not from the 60s, I was born in 63, but I was at the tail end of the muscle car boom, so it still kind of stuck with me because my first interest was Hot Wheels back in 68 when they came out. So that's when I really got a kind of a love affair going with the automobile. Well, tonight we have an interesting case. This particular case arises out of federal court action. It was a personal injury lawsuit that was filed by the plaintiff for an accident that occurred on, to me, a road that sounds suspiciously similar to the Tail of the Dragon. Now, I had the pleasure of driving the Tail of the Dragon back in 2017. I flew down to Georgia, and it was about midnight when I got to the Hertz counter to rent the Shelby Mustang GTH that I planned to use on the Tail of the Dragon. And the funny exchange that happened at the Hertz counter was they asked me, the lady behind the counter said, "So what brings you to Atlanta?" And my response was, "Your car." So I don't know how that went over with them. They may have had a little bit of a tinge of fear run through their veins when they heard that because, well, I'm renting a Shelby Mustang, and what are you going to use a Shelby Mustang for but for rotting it and having all kinds of high-speed fun and thrills? But in any event, I've driven the Tail of the Dragon. It's a beautiful road. Goes through the Smoky Mountains from Deals Gap, North Carolina, through Tennessee. I've driven the Cherryhollow Skyway. So the case that I'm going to be discussing now involves the personal injury case where the court allowed admission into evidence of prior speeding tickets of the plaintiff. The plaintiff had a history of a lead foot, and the court allowed that evidence in and allowed the jury to hear this prior evidence, and it resulted in an adverse finding for the plaintiff and this subsequent appeal. So let's get into the case. This is a case of Sparks versus Gilly Trucking Company, Inc. The case citation is 992 F2D 50. And it's an oldie. It was decided way back in April of 1993. But in the law, it doesn't really matter when a case is decided because if it's still good law and has not been overturned, it's still going to be taken into consideration today. It's called a notion or a Latin phrase called stare decisis, which means let the decision stand. So courts will look to case law, even older case law, to see how courts decide these types of issues. And if the case hasn't been overturned, as I mentioned, or not overruled or distinguished, the court's going to look at this case, and subsequent courts are going to look at this case to decide on how future cases will go at the trial level. So let's get into it here. Let's go to the facts. This case arises out of a drive late on a June afternoon of 1987 where Mr. Sparks was driving up a mountain near the North Carolina-Tennessee border. Sounds like the Tail of the Dragon to me. And he was driving in his red Corvette. Interesting how the court identified the color of it and the type of vehicle. So red Corvette automatically may draw an adverse inference that maybe this guy is a speeder. Anyway, he's driving in his red Corvette when a logging truck came around the mountain in the opposite direction. Once again, this sounds a lot like the Tail of the Dragon, which is a two-lane road, and it has problems to this very day with 18-wheel rigs using it when they're not supposed to. Well, it uses the 18-wheel rigs use the tail of the dragon because their GPS redirects them to this route as a shortcut. And it's a disaster because there are so many turns and switchbacks. It's 11 miles with 318 turns. There's so many turns and switchbacks, they can't stay in their own lane. And sometimes when they're coming around a corner and you're driving maybe at a higher rate of speed, they're going to be right in your lane and you're going to have an accident. So you have to really regulate your speed and be aware of these dangers. Well, in this instant case, uh, after the vehicles passed by each other, Sparks lost control of his car and hit a tree. So he saw the logging truck, and the logging truck came down the mountain road in the opposite direction. So he lost control and hit a tree and sustained serious personal injuries. Well, Sparks sued the Gilley Trucking Company, the owner of the logging truck, alleging negligence. And Gilley Trucking filed a defense contending that Sparks' own negligence contributed to the accident. So you can file what's called an affirmative defense, which says, well, yeah, we may have been at fault, but we're not admitting it. But you were at fault too, therefore you should take nothing. So if you're negligent, you're responsible for your own injuries if you're a certain percentage. So at the trial, Sparks testified that the truck was traveling in the middle of the road and that in trying to avoid a collision, he ran off the road and hit a tree. The driver of the truck testified to different facts, stating that Sparks was driving at an excessive rate of speed in the middle of the road and lost control when he swerved to avoid hitting the truck. So what the trucking company did, the defense did, to advance its theory that Sparks was speeding, or actually racing at the time of the accident, the Gilley Trucking Company was allowed to introduce over Sparks' objection evidence that Sparks had been convicted of speeding on several prior occasions. Relying on Federal Rule of Evidence 404B, the district court admitted the evidence to show intent, preparation, plan, or motive to race or speed on the day in question. This evidence formed a principal part of Gilley Trucking's defense that on the day of the accident, Sparks was contributorily negligent. It means Sparks contributed to his own injuries because of the speed, the excessive speed that the trucking company believed he was engaged in. So actually, Gilley Trucking also presented testimony of the investigating police officer who arrived at the scene after the fact, I might add, who estimated Sparks' rate of speed immediately before the accident was 70 miles per hour. Now, I've driven the tail of the dragon. I don't think you can get to 70 miles per hour with all those switchbacks because there's so many turns. You're probably going to be at most 55, maybe 60 miles an hour. Unless you're an incredible driver, it's highly unlikely you're going to get to that speed, but we'll see later here. The jury found that the negligence of both drivers contributed to the accident and, as required by North Carolina law, rendered judgment for the defendant trucking company. So on appeal, Sparks contends that the district court erred in admitting both the evidence of prior speeding tickets and the expert testimony. So the whole issue in this case was it proper for the court to allow admission into evidence of prior speeding tickets of this particular plaintiff? Merely because he owned a red Corvette and he had prior speeding tickets, are those prior speeding tickets relevant to this accident, really? And ultimately, they really aren't. There's no evidence to show that because you had speeding tickets in the past, that on this particular occasion, you were in fact speeding. So the court said no to that. They threw it out, the appellate court. And the reasoning basically goes as follows. Okay, the principal issue turns on whether the fact that Sparks was convicted of speeding on prior occasions had a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. So they analyzed it in conjunction with probative value. Is it more prejudicial or does it have greater probative value, which means value to advance the strength of the case? Does that outweigh the prejudice of admitting the tickets? And this court held that the probative value was outweighed by the prejudice of letting the jury hear about the prior driving record of the plaintiff. It was highly prejudicial. So the court goes on to state that with an intent to commit a crime that's at issue, and speeding tickets are kind of a quasi-criminal offense, so it's on the borderline there. With there's an intent to commit a crime at issue, we have regularly permitted the admission of prior acts to prove that element. For example, a criminal defendant, cannot deny knowledge of drug trafficking or an intent to traffic in drugs, and at the same time preclude the admission of the government's evidence of prior occasions when he willingly trafficked in drugs. So you're allowed to bring in evidence of bad acts or bad prior acts or a pattern of behavior when the defendant or the individual whose evidence you're offering against it, the individual, they have a pattern and they're denying that pattern. You may wonder why they disallowed the speeding tickets. Well, speeding tickets can be inadvertent. They're not really something where you can show intent. And the standard in a civil suit, it's not going to intent as much as it is negligence. And this was a negligence case. It wasn't an intentional acts case. The court goes on to say in common law negligence, the issue is generally not the defendant's state of mind, rather the fact finder must determine whether the defendant was acting as a reasonable person would have acted in similar circumstances. In this case, Gilly Trucking was attempting to prove that Sparks was speeding or racing at the time of the accident and therefore driving in a negligent manner that contributed to the resulting accident. Yet proof of negligence does not require a showing of intent or plan, the stated purposes for which the prior speeding tickets were admitted by the district court. Moreover, prior acts of speeding alone do not establish intent because a speeding violation does not depend on intent. A speeding ticket may be issued regardless of the defendant's state of mind. Indeed, accidental or inadvertent speeding may result in the issuance of a speeding ticket. So you could be driving on the interstate and maybe doing 80 in a 70-mile-an-hour zone, but you're keeping up with traffic. So you're really not intending to speed. You're basically just trying to keep up with traffic. So the distinguishing factor here is intent. And to admit those speeding tickets doesn't show an intent on this occasion at issue that the driver or the plaintiff was actually speeding. So they're inadmissible. It's too prejudicial. With regards to the officer, there was an officer that was at the scene of the accident, and he investigated, and he testified as an expert for the trucking company. And he said that immediately prior to the accident, he admitted or estimated the speed of the plaintiff to be about 70 miles per hour. And he argued the plaintiff argues that the court should not have admitted this expert testimony because the officer didn't conduct a proper examination of the scene. The plaintiff stated that it was without sufficient factual basis because the officer did not measure the friction on the highway surface in question before applying a coefficient of friction to the length of the skid marks when estimating Sparks' speed. So although the court threw out the speeding tickets and remanded the case for a new trial, by the way, the court did say that it's within the trial court's discretion as to whether to allow the testimony of the officer. The whole reason being that the counsel for the plaintiff can certainly cross-examine the officer and impugn his credibility with regards to his measurements. So that's going to be left to the trial court to decide whether the officer is admissible as an expert witness. And at the trial level, the trial court's going to have that discretion. So ultimately, this is a relatively simple case, but a good one where there's civil litigation. You cannot admit prior speeding tickets to show that the plaintiff or the defendant were speeding on that occasion, at least not in this area or in this district. So, and that's probably going to be true of a number of other districts. It's going to obviously depend on the court. It's going to depend on the state. This was a federal court case. So the court ultimately threw out the tickets, remanded the case. They reversed and remanded the case for a new trial. So the plaintiff's going to get their day in court again, but this day in court is going to be sans prior speeding tickets. So I don't know what the result was on that. It may have ultimately settled after this appeal. Who knows? But that seems to be the general state of law in this area of the federal courts in the United States. So it was a rather interesting case, and many more like that to follow in upcoming episodes. And I hope you enjoyed this one. If you like, please subscribe. And have a good evening and drive safely. Happy motoring.